My name is Chuma, Chinye, and I am your family lawyer. I was called to the Nigerian bar in 1988, and I have over 35 years experience in family law practice. I've helped countless families navigate Nigeria's complex legal terrain, and I am desirous of bringing this knowledge and expertise to you free of any charges. About an aspect of marriage that is not too pleasant, but occurs all too frequently. We're talking about divorce. Today's episode will explore the legal implications of separation and divorce under the Marriage Act. We'll be talking about the rights to maintenance, the division of property between spouses, and we'll also talk about child custody arrangements when marriage goes south. Section 15 of the Matrimonial Causes Act lays out the grounds for this irretrievable breaking down of a marriage. It is paramount that you should know your legal rights, especially regarding the property that you own in the family, regarding financial support, and regarding, most importantly, child custody. And please, whilst you are this, or before you even get started, talk to a lawyer. Next up, let's talk about bigamy. This big word, bigamy. It is the ultimate crime in the world of monogamy. The offense of bigamy is committed when someone who is already married, legally married under the Marriage Act, marries another person without first ending the initial marriage. It is not just a betrayal. Under the law, it is a crime. It is a felony. That is the one they call big crime. The small one is called misdemeanor. The big one is felony. When you marry someone else while still married, it is a felony. If you are caught, if you get caught, you could end up in prison for 7 years. And you heard me right. 7 good years of your life could be spent behind bars. The nearest one is in Kuje. The law takes this seriously because bigamy actually messes up with the very foundation of marriage. Have you ever wondered what makes an Islamic marriage lawful, even though it's not a marriage conducted within the ambit of the Marriage Act? We'll break down what an Islamic marriage is, and then we'll talk about the roles of the wali and the mahr and why these elements are crucial. Just like in other marriages, both parties need to say, yes, I do. That is to say, the husband must say so and the wife must say so. But then there's a lot more. You need at least 2 witnesses to seal that deal and make it a proper marriage.
Episode of Your Family Lawyer will explain divorce under Islamic law, focused on the 2 main forms of a divorce. That is talaq, which is initiated by the husband, and khul, which is initiated by the wife. Explore the grounds for divorce, the role of the Sharia courts, and then we'll look at a story where talaq was indeed contested in court. We'll also look at child custody under Islamic law. And by the end of this episode, you have a clear understanding of the rights of women and of men, and even that of children, in the cause of divorce under Islamic law. Divorce is permissible under Islamic law, but it is not encouraged because marriage is considered a sacred contract under Islamic law. However, when the cookie crumbles, when the marriage breaks down irretrievably, the law provides for 2 primary forms of divorce. The first, talaq, is a form of divorce initiated by the husband. It can be declared either verbally or in writing.
We need to put this polygamy under Islamic law in perspective. It is permissive. The law permits it. But it's important to note that that permission comes with strict conditions. A Muslim can marry up to 4 wives, but the Quran makes it clear that this can only be done under the condition of fairness. That is to say, if you fear that you will not be able to deal justly with more than 1 wife, please marry only 1 wife, just 1. In other words, there's a misconception that as a Muslim, you are required to marry many wives. This is not the case. It is not true. Muslims marry 1 wife, but if they have the means, they are allowed to marry up to 4. And when you do so, it means that you must be able to treat all wives fairly and equally. And this includes your financial support to them, devotion of time and affection to each and every wife. Islamic law emphasizes the need for justice in dealing with all wives, and failure to meet this standard can lead to legal and religious consequences. Islamic law ensures that every wife has equal access to the husband's wealth, to his time, to his every resource, equally with the other wives. It's a new day, and I'm glad to be here with you. I welcome you to another episode of Your Family Lawyer. And today, we'll be talking about traditional marriages under native law and custom in Nigeria. It's quite boring to read about this in textbooks, but forget about that. Today you will see where culture and law get really interesting, because we're going to dive into the cultural significance of traditional marriages. We'll talk about the key elements of traditional marriage like dowry and family involvement. And we'll even throw in a juicy story about a dowry dispute that had everyone talking as at the time it occurred. Alright, so let's kick things off by talking about why traditional marriages in Nigeria are such a big deal. They are not just ceremonies, they are epic events that unite two families in bonds stronger than blood relationships. We're talking about serious cultural interplay here that brings one man, one woman, and then transforms them into wholesome family of love and of building generations. In today's episode of Your Family Lawyer, we're continuing our discussion on traditional marriages under native law and custom in Nigeria, with a focus on regional variation. That is to say, the cultural differences in the ways the various ethnic groups and nationalities that make up Nigeria conduct traditional marriages. We'll explore how the practice of traditional marriage differs from region to region, with unique ceremonies and customs across Nigeria's diverse ethnic groups and nationalities. Finally, we'll look into the legal challenges that arise when customary marriages need to be enforced in our formal courts. Traditional marriages in Nigeria are as diverse as the country itself. Each region and ethnic group or nationality brings its own unique flair to the ceremony, making it always a vibrant and culturally rich experience. First, being Igbo myself, I would like to give you a first-hand knowledge of the fascinating traditional rites of the Igbos in southern Nigeria. A man usually has the right to be cared for and nurtured by his wife. This includes the provision of food, care, and maintenance of the home, the children, and of course, the other room. It is the right of a woman to be protected by her husband. And when a husband fails to do this, traditionally, you're not a man. Okay, let's knock on the doors of certain things that limit these spousal rights. It's easy to talk about them in backward, but when you bring them to practice, in Nigeria, certain things inhibit how we realize or the realization of these spousal rights. One of them is the patriarchal nature of our customary laws. The man is on the driving seat often, and this often limits the rights of the wives in customary marital relationships. And of course, the variations in customary laws affect spousal rights. As I mentioned a little earlier, some parts of Igbo land, when a woman is married, she ceases, for all intents and purposes, to be part of her maiden family. And of course, there have been many cases open in our political landscape where a woman wants to contest an election in her place of origin, and she's told to go to her husband's place. And then she goes to the husband's place. They say, no, you don't come from here. Go to your family or the state where you come from, or the local government you come from to contest an election. These are undesirable situations, and it's our hope that the laws of Nigeria will continue to address these issues in a dynamic way. Then you have the situations where customary law conflict with statutory provisions, including the Nigerian constitutions. It's needless to say that when this happens, the statutory law or the constitution takes precedence, and then the customary law is overruled. Now let's talk a bit about how the home runs. In practice, whilst the husband generally has the duty to provide for the wife and the children, the wife is expected in turn to support the home through non-financial means, such as managing the household and caring for the children and her husband. The rights of the spouses are often closely tied to how well they play these roles within the marriage. And failure to meet these expectations can result in disputes. And disputes are often resolved by elders in the family or the community. When it gets too difficult, the customary courts. Yes, we just talked about customary court and resolution of disputes in customary marriages. Are you ready for a real-life drama? The story I'm going to tell you involving the family of Adebayo has this drama in high doses. Here, the husband tried to dodge, to avoid, evade his financial responsibilities to his wife by arguing that their marriage, their traditional marriage, wasn't legally valid because it was not registered under the Births, Deaths, Compulsory Registration of Marriages Act of 1992. How could a man reason this way? You got married to a woman. You went to her family. You paid the bride price. She was handed over to you. Then you wake up one day and you say, that marriage is not valid because I did not register the marriage. Let's see what the court had to say about this. Something happened in Okrika, in the present-day Rivers State, many years back. Under Okrika custom, there is what is called Iya, which is the final level, the final grade of marriage, when the woman can proudly say, I have a husband. But when the Iya ceremony is done, the marriage could be dissolved at will by the husband by simply sending the wife back to her parents. The woman was then free to remarry, and any children of the subsequent marriage belong to the new husband. Similarly, the wife could call the husband, summon the husband before the chiefs, and have them work out how much should be paid back to him if she intended to divorce him by way of refund of the bride price and all other expenses, including what is called Igbo and Okuru. But if the husband does not accept the proposed refund, that is the end of it. The woman would not be able to divorce him. The marriage is deemed to be subsisting, and there was nothing the woman could do to get free from it. And any children she had, if she does have children with a new man, those children were regarded as the children of the first husband, and they were constantly treated as bastards. In other words, as children without heritage, without lineage. In this particular case, the father of a woman who was married and whose Iya ceremony had been performed, decided to go to court to ask the customary court to compel the husband of his daughter to accept a refund of the bride price and all other things that he may have done by way of securing her hand in marriage and the conclusion of the Iya ceremony. This woman had in fact left the man for another man years back and had attempted several times to return the bride price, but the man refused. And then the children she had for the other man were considered to be children of the husband she had left, and therefore deemed, quote unquote, illegitimate. The customary court agreed with the woman's husband and struck down this obnoxious or reclamative law and custom, which permits a man to divorce his wife but prevents her from being able to leave him. Let me put it differently. This reclamative law and custom. Under it, a man can prevent his wife from divorcing him forever and ever until death does them part, though he has a free right to divorce her at his will. This clearly is a custom that is repugnant to natural justice, equity, and good conscience. And so the courts will not allow it to stand. And this particular court did not allow it to stand. Let's see how it played out actually in the courtroom.